Government Business Notice Number 1, standing in the name of Mr Burgoyne to present the Water Amendment Aboriginal Water Reserves Bill 2025, Serial 21.
Minister.
Madam Speaker, I present a bill titled Water Amendment Aboriginal Water Reserve Bill 2025, Serial 21 and table the explanatory statement. Madam Speaker, I move the bill be read a first time. Madam Speaker, I present a bill entitled Water Amendment Aboriginal Water Reserves Bill 2025. The purpose of the bill is to amend the Water Act 1992 to improve the efficiency and administration of the Water Act and to ensure regulatory decisions can be made with respect to the Aboriginal Water Reserve. The bill introduces amendments to support the activation of Aboriginal Water Reserve to provide economic benefit to Aboriginal people and the Northern Territory. This Northern Territory government was elected on a clear mandate to rebuild the Territory economy, something that had all but come to a standstill under the previous Labor government. This government is committed to rebuilding the economy through a range of reforms that provide a strong foundation for growth with robust regulatory frameworks, world-class environmental protections and long-term certainty for business investment. The introduction of legislation for the Territory Coordinator and the removal of third-party merits review into the Legislative Assembly supports this commitment. And Madam Speaker, so does this bill. Water is an enabler for economic development. We use it for agriculture, horticulture, aquaculture, for mining and for onshore gas developments. And if we are to grow our territory, then we need to ensure that the water made available for economic benefits is used. For too long, access to the Aboriginal Water Reserve has been impeded by distractions, caused by ambiguous legislation and because the former Labor government was unable to find a solution to a problem of its own creating. A problem created because the former government did not implement its own policy. This bill corrects this ambiguity to make water reserved for Aboriginal economic development available for those who are ready to start doing business in the Territory today. An Aboriginal water reserve is a volume of water set aside for Aboriginal economic benefit. This water is allocated under a water allocation plan to Aboriginal landowners relative to the size of their land holding. The Aboriginal land must be greater than 1 hectare and it must have a certain relationship with the water resource being managed under a water allocation plan. How this relationship is described under the current Water Act is unclear, and subsequently, its interpretation does not align with the underpinning principles of water resource management in the Northern Territory, specifically that water is tied to land. When Aboriginal water reserves were introduced into the legislative framework in 2019, those amendments created ambiguity and operational challenges. This bill removes those ambiguities and reduces operational challenges. Specifically, Madam Speaker, this bill will do 3 things. Firstly, this bill makes clear the land that is eligible for designation to an Aboriginal water reserve under a water allocation plan. As I previously mentioned, water is tied to land under the Water Act. The land must have a certain relationship with the water resource being managed under a water allocation plan to which the Aboriginal water reserve applies. Not only must the land be more than 1 hectare, if the water allocation plan is managing groundwater, then the groundwater must be beneath the land for that land to be designated as land to which an Aboriginal water reserve applies. And for the owners of that land to be assigned a share of that reserve in the water allocation plan, this has been the practice for water allocation planning to date. The amendments proposed in this bill will make that practice clear under law. Secondly, the bill creates efficiencies and removes elements of the legislation that have created a distraction to the water allocation planning processes. The current requirement to consult specifically with land councils regarding eligible land before it is designated in the water allocation plan duplicates consultation processes already undertaken as part of the development of those plans. Eligible land for the purpose of Aboriginal water reserves under the Water Act. This includes Aboriginal land under exclusive native title, land declared under Aboriginal Land Rights Act, and freehold land owned by registered Aboriginal corporations. Through existing water allocation planning practices, all groups are equally consulted with the opportunity to participate in water advisory councils and through public consultation processes. The Department has also been making great inroads into increasing Aboriginal participation in these planning processes. Madam Speaker, it is the Departments of Land, Planning and Environment that has the skills and capabilities to complete the task of identifying the land of the particular tenure and size and its relationship with the water. The Department holds and administers Northern Territory land title information under the Aboriginal Land Rights Act and freehold land, and has established relationships to be able to draw on the national data sets for native title land. The Department is the expert on land titles in the Northern Territory and is responsible for generating and managing the spatial information that shows where our groundwater resources are and where our surface water flows. The Department is best placed to identify eligible land and has existing consultation practices and responsibilities that ensure this information is available to all landowners before a water allocation plan is declared. Finally, with these amendments, we are stepping aside from attempting to prescribe a one-size-fits-all consent process for Aboriginal people to access their Aboriginal water reserve. The amendments proposed under this bill will allow eligible Aboriginal landowners to determine how and who gives consent for a person to apply for a licence from the reserve. We are creating this opportunity by removing the requirement to establish regulations that prescribe the class of people who can give consent and the process that must be followed in determining consent. Government does not impose on any other individual, group or company how it goes about deciding to apply for a water extraction licence, and we will not do this for Aboriginal landowners. To enable this autonomy, this bill proposes that the controller of water resources be satisfied that an application for a licence has come from an eligible Aboriginal person, or if that eligible person so wishes, someone whom they have made an agreement. This government respects Aboriginal decision-making practices and traditions and is removing itself from prescribing a process for consent that already exists within tradition and through existing practices. These amendments will provide the space for Aboriginal landowners to decide and apply their own processes for determining who can apply for a licence. The controller of water resources, the independent statutory decision-maker, in deciding an application for a water extraction licence in relation to an Aboriginal water reserve, will need to consider who the applicant is and whether they are an eligible Aboriginal person as specified under the water allocation plan. How the controller satisfies himself of that may vary depending on the land tenure, and I will be encouraging the controller to develop some guidance that explains this. Ultimately, a decision to grant a water extraction licence rests with the controller of water resources, and they are directed in their decision-making by the Water Act. In the case of Aboriginal Water Reserve, after considering who has applied for the licence, the controller must consider several other factors that include the relevant water allocation plan, water availability and impact on other water users. It is through this process that the controller considers the impact of taking water. Applying for a licence does not guarantee a licence will be granted. And equally, consent to apply for a licence from an Aboriginal landowner does not mean a licence will be granted. Once an application is accepted, the assessment process commences. It is through this public process that the impact of taking the water is considered, and it is through this process that all people who may be impacted by the take of water also have an opportunity to make submissions for the controller's consideration in making a water extraction licence decision. These amendments clarify the criteria for granting a water extraction licence with respect to an Aboriginal water reserve. Madam Speaker, ultimately, this bill makes amendments that will improve the Territory's water resource legislative framework and support economic development for Aboriginal people in the Northern Territory. There will be some Aboriginal landowners that are ready to reap these benefits now, and there will be some Aboriginal landowners who are not. But these amendments create an environment that facilitates Aboriginal landowners ensuring they can take advantage of available economic benefits when the opportunity arises and when they are ready to do so. I am pleased to commend this bill to honourable members and table a copy of the explanatory statement.
The question is that the bill be read a first time. Those of that opinion say aye. To the contrary, no.
Aye.
I think the ayes have it. The clerk.
A bill for an act to amend the Water Act 1992.
Minister.
Madam Speaker, I move that the second reading of the bill be made in order of the day for the first Assembly meeting after 28 days have elapsed.